true that West Virginia versus EPA, I think, was partially driven by non-delegation doctrine concerns and concerns about deferring to agencies when doing so threatened our separation of powers. After Chevron has been overruled, of course, that might be relevant in a smaller number of cases.
Tell me about the Loper Bright case.
Sure. So Loper Bright is the case that overruled the Chevron Doctrine. And the Chevron Doctrine originally required that if there is an agency statute that governs an agency's conduct, the agency gets deference, meaning a thumb on the scale, when it's interpreting what that statute might mean as it's carrying out its duties. Loper Bright determined that that framework was inconsistent with the Administrative Procedures Act, and instead that moving forward, courts should decide all of those statutory interpretation cases as a de novo matter, meaning the agency doesn't get any sort of special head start.
How much deference did a federal court have to give to an administrative agency under the Chevron Doctrine?
Sure. So the court would originally make a step one determination about whether the statute was ambiguous or not. That's in the eye of the beholder sometimes. But if the court determined that the statute was ambiguous in the relevant sense, meaning it didn't resolve the question the agency was facing, it would defer to the agency's view of the meaning so long as the agency's interpretation was well explained and reasonable.
What's the relationship, if any, between Loper Bright and West Virginia v. EPA?
So that's a fascinating question. I think, West Virginia versus EPA applied Chevron, but said we're less likely to find ambiguity, and indeed Congress needs to speak clearly if the agency is purporting to resolve a matter of, in the court's terms, political or social significance. And following Loper Bright, of course, there is no deference. And I think some have commented, including Justice Barrett, that the best way to think about West Virginia versus EPA in interpreting statutes is that it informs the context of how we understand what the statutory terms mean in the context of an agency delegation. So the fact that the agency is purporting to carry out its duties might resolve whether or not the particular question is sufficiently clearly delegated by Congress.
That just seems to me like a distinction without a difference. I mean, doesn't Loper Bright wipe out the need for West Virginia v. EPA? Why do we still need a major questions doctrine?
So it's certainly true that West Virginia versus EPA, I think, was partially driven by non-delegation doctrine concerns and concerns about deferring to agencies when doing so threatened our separation of powers. After Chevron has been overruled, of course, that might be relevant in a smaller number of cases, but I do think that the major questions doctrine still has vitality in understanding the best meaning of the statute as Loper Bright now requires.
Viewers, let me ask you a question. Who decides how this country is run? Is it you, your elected representatives? Or is it a bunch of unelected bureaucrats hiding behind the veil of agencies in D.C.? Because if you care about the Constitution, about liberty, about self-governance, you need to know about the Loper Bright case. It just overturned one of the most dangerous judicial doctrines this country has seen in the last 40 years, the Chevron Doctrine. And friends, that is a very good thing. Welcome back to another episode of The American Enigma. Let's break this down in plain English. For decades and decades, courts gave the benefit of the doubt to federal agencies when interpreting vague laws. That means if Congress passed a law with unclear language, and an agency like the EPA or the IRS decided what that language meant, courts would basically say, well, the agency probably knows best. We'll let them do what they want. That was called Chevron deference. And it put an unelected administrative state above the judiciary and above the American people. Now let me be real with you. This doctrine was a disaster for liberty, for business owners, and for constitutional order. It turned federal agencies into little kingdoms with lawmaking, enforcement, and judicial power all rolled into one. Does that sound familiar? That's called tyranny. Well, the Supreme Court finally said enough is enough. In the Loper Bright decision, the justices struck down Chevron. They said, from now on, courts, not bureaucrats, will interpret the law. That's called de novo review, and it means every statute gets a fresh, unbiased interpretation by the courts.
What's the public rights doctrine?
So most recently, the public rights doctrine has been applied in the Seventh Amendment context, and the Supreme Court has a decision named Jarkissi, where there's a line of precedent saying that if a matter involves public rights, so the conferral of a public benefit, for example, that might be the type of matter that Congress can vest adjudication of in Article I tribunal or in an administrative agency.
What's a public right?
That's a very difficult question to answer in many cases.
That's why I'm asking you.
Yeah, so I think the best way to think about it is to contrast it with private rights. And what the Supreme Court has instructed with respect to private rights is that they're what we would think of as common law type claims. So contracts, property, torts, the stuff of Westminster in the court's terms. And so if you have a matter like that, that's the type of matter that needs to go before a jury to ensure that the Seventh Amendment's jury protections are abided. By contrast, if there's an internal administrative process, Social Security benefits, things like that, that looks more like a public right that wouldn't have existed but for the government granting it.
And what did the Supreme Court hold in, was it Jarkissi?
That's right.
What did the Supreme Court hold?
So the Supreme Court there held that certain matters of the Securities and Exchange Commission actually looked more like common law fraud claims and more like property-based claims that must be tried to a jury in court and cannot be vested in the in-house SEC proceedings to be tried before an administrative tribunal.
My time is done. Thank you, Professor.
Okay, against my better judgment, Senator Schiff, I promised Senator Schiff, because I skipped him in order, I promised him one more question. All right, Senator. This gavel will never come to me again, though, if you ask more than one question. So we'll hold you to it.
Well, I've got the gavel.
This is
Well, there we go.
this is just in honor of Mike Lee's birthday.
Yeah, be sure I understand, Professor. District court rules in a case. You got plaintiff or defendant and defendant. You're representing the plaintiff. Your plaintiff is very unhappy. Are there any circumstances under which you would advise the plaintiff to ignore the federal court order?
So of course, as a judicial nominee, I would be trying to issue proper orders.
I don't want to split hairs here.
No, the normal process is to
I know what the
seek
normal
appellate
process
review.
is. Can you think of any circumstances where you would tell the plaintiff, nope, you don't pay attention to this federal judge?
So the problem with answering it that categorically is that there are potentially some very extraordinary situations you could imagine
Like
that
what?
could come before me as a
Like
judge.
what?
So this is a subject of
I'd be
tremendous
careful
scholarship.
there. I'd be real careful.
All right, Senator. All right. I promised you one. That was 4, I think.
Okay.
See what you started, Adam.
Now, this is exactly how the Constitution intended it. Agencies don't make the law. They don't interpret it. That's the job of the courts and we the people through our elected representatives. Now, some people are wondering, what about the West Virginia v. EPA decision? That was another major win where the court said federal agencies can't make sweeping decisions on issues of political or economic significance unless Congress explicitly says so. And you know what? That principle still stands. It's now part of what we call the major questions doctrine. Loper Bright didn't erase it. It made it stronger. It said we're not giving bureaucrats a blank check ever again. Let me tell you something, friends. This is not just about legal theories or court doctrines. This is about freedom. It's about stopping the Environmental Protection Agency from shutting down your family farm because of a puddle. It's about the SEC not prosecuting people without a jury trial. It's about restoring the balance of power in this country and putting the federal government back in its constitutional box. There was also discussion about public rights and private rights. Here's the deal. The government can decide who gets Social Security or veterans benefits. Those are public rights. But when it comes to your property, your contracts, your livelihood, those are private rights, and they must be protected by a jury trial, not by some pencil-pushing bureaucrat behind closed doors. That's what the court reaffirmed in Jarkissi, another vital decision. Fraud claims, property rights, those go to a jury in a court of law, not to some unaccountable in-house tribunal at the SEC. That's what the Seventh Amendment is for, and it's about damn time we honored it. Now, toward the end of the hearing, a senator asked a very sharp question. Would there ever be a time when a plaintiff should just ignore a federal court order? And what did the judicial nominee say? She danced around it, said it would depend on extraordinary circumstances. Let me be clear. We are a nation of laws. If we start picking and choosing what court orders we follow, then we are no better than the tyrants we claim to oppose. But, and here's the catch, those laws must be constitutional, and the courts must not rubber stamp executive power. That's what made Loper Bright so important. Puts the power back where it belongs, with the judiciary, not the executive branch. So what does this mean for you, the average American? It means the IRS can't make up rules and expect courts to back them up without question. It means the EPA can't invent new climate policy from thin air. It means agencies can no longer expand their power every time Congress gets lazy and writes vague laws. It means accountability is back. And that's a win for every farmer, trucker, entrepreneur, and citizen who's been crushed by federal overreach. Look, I love this country. I believe in its founding principles. And for too long, we've let the administrative state trample on our freedoms. But the tide is turning. With decisions like Loper Bright, West Virginia v. EPA, and Jarkissi, we're clawing back our God-given rights and restoring the constitutional order our founders intended. So stay vigilant, stay informed, and never forget, we the people are the rightful rulers of this republic. Not the bureaucrats, not the agencies, not the alphabet soup of federal overreach. It's our country. Let's take it back. If you enjoyed this video, hit that subscribe button. Drop a comment. Share this video to your friends and smash that like button for more uncensored analysis. See you on the next episode of The American Enigma.